I'm sorry, I won't show my face due to a weak connection that I have. I think we've got a good number and we can start our session this morning. Our session is Purposeful Aging. It's the 11th session, and as all of you might have realized, we are nearing the end of 2024. Purposeful Aging is inviting all of you to take a moment and reflect on the past 10 sessions. This year, we've had a lot of sessions, 10 of them. Some have been challenging, others very enlightening, and all of them contributing to our growth and understanding. In all the sessions covered so far, you've been very open, you've discussed, you've shared insightful journeys, friendship, supportive friendship, and growth. Purposeful Aging team wants to thank you so much for your unwavering participation and commitment. Every end of last Saturday of the month, you've been with us. Thank you very much, and you are most welcome this morning. As older adults, we all know many of us have our loved ones in this phase of our life, responsibilities of different magnitude, and it is important for us to close or as we near the close of our lives, to answer all those questions which disturb us, which come to our minds as we age. This morning, we are blessed to have a session which will help us to look at how to reflect on our values and our legacy, and to see how we can have all this fulfilled as we depart or as we end our lives, as our lives come to an end, sorry. Today's session is going to do just that. This session is very vital. The topic is our legacy and our way. Your way, your legacy, your way. And we need to understand the legal issues around succession and estate planning. This session is designed to empower you with the knowledge to take control of those important decisions that you have to make. And this is not only older adults, but all the caregivers. As we know, some are not yet in the bracket of 60 and above. Going to introduce our speaker, just after reminding all of you that when the session is on, let us keep our speakers muted. Let us put all the comments and questions in the chat. And when it's time for Q&A, we can raise our hands and contribute direct or still contributing through the chat. So our speaker this morning, we are very privileged to have Counsel Ali Bogere. Counsel Robert Ali Bogere, you're most welcome. I'll give a background of his education. Counsel Robert Ali Bogere holds a Bachelor of Laws degree from Makerere University and a postgraduate diploma in legal studies from the Law Development Center. His work journey: he has served in the Ministry of Justice and Constitutional Affairs for more than 15 years and with the Directorate of Administrator General. He's an external examiner at the Law Development Center back course, as well as a course facilitator at several universities. When it comes to purposeful aging, Ali Bogere is a facilitator and has been a part of the team that developed the curriculum for retooling, retiring, and career transitioning public servants at the Civil Service College in Jinja. He played the lead role in the amendment of the succession laws in Uganda. Ali Bogere has been always ready to exchange ideas and share knowledge. I think you agree with me that this is a very, very right person we need at this time of our lives as older adults and caregivers. Ali Bogere, you're most welcome this morning.
Thank you very much for having me.
And just before you start, I just want to let you know that before you, we have a very eagerly waiting older adults. These are people above 60 years. And we have caregivers, a section of caregivers do look after the older adults, or what you want to call elderly, on a 24-hour basis. They stay with them at home and literally help them in everything in their aspect of their lives. And then there is a group of those who are below 60, but do care for the elder, the above 60 group. These are people who make decisions, who support them financially, move them and all that. So, and at present, we do have about 33 of them online and very, very ready to listen to your advice. So after about 45 minutes, we'll have a Q&A where we assure you clear all our worries and our questions. Ali Bogere, you're most welcome. You can dive in right now.
Thank you very much. My brief today was that I make this. I don't know whether you can hear me.
Yes, we can.
Okay, that I make this as simple as possible, because we sometimes give these talks to lawyers and the judicial officers, and you tend to get lost in the legalese.
Yeah.
I will speak like I speak to the clients who I have when I'm at the Civil Service College. Succession matters are very emotive. Many people, the majority of Ugandans, probably well over 90%, don't make wills. One time I was I was facilitating a class at the Makerere Law School, and I talked about it, and the professor at that time who was taking the class, who was in charge of the class, when I said that the majority of even lecturers at Makerere University don't have wills, she thought it was a joke, and later she told me she did a small survey of hers, and probably there were less than 10% of people in the legal profession at the university who had wills. So it's a general problem in this country that people equate making wills with dying. They tend to speak in Luganda and say, you are you are a harbinger for bad omens and ill will against yourself if you make a will. And I always tell people that it is not true. I always tell people that when I give the talk and I say, please make wills. Then someone says, you want us to die? So I always tell them, no, I will not lie to you that you and I will not die. That's a given. But there is dying well. There is a Chiganda, an English saying which says, if you are to eat a frog, eat a fat one. Although there are some cultures, even in Europe, which eat frogs. But the essence of it is better to do something. If something is inevitable, do the best. So since death is an inevitability, there is no reason why you should fear it, why I should fear it. And there is all the reason to get prepared for it and say, okay, let me set my affairs in order. I once made a will for a gentleman who had cancer. And people, as is normal Ugandan practice, they lied to him that he has some other things. And he was taken to so many witch doctors until he was taken abroad, and the Wazungu, being who they are, they told him, you have 3 months to live. Make a will. And he came and we made a will, and within 3 months he was deceased. But he made a will which was very good, which cared for his youngest children so that at least they have an education. And that is the essence of what we do in succession planning. Most of us in Uganda, especially the men, we have what I call United Nations families. You have children of your spouse. Then you have children who will come out the day you die. Then you have children whom you don't even know that they are yours. Their mothers know. Oh, actually, even some mothers don't know. And if an estate dispute will arise in the estate of their supposed father now, and they will do DNA, and the DNA tests will come out and show that they are not, then the mother will remember. The mother will remember that, hey, I had a fling with one of the members of Aging Well, the Purposeful Aging group. I had a fling with him. Then you will also have probably died. Your estate has been distributed. Then that child will come this side and find nothing. So we have that type of relationships in this country. Most Ugandans, there's a survey which I usually like to point out, which was done by a Christian organization, which said 78% of Christians in Uganda cheat on their spouses. Now, we have that kind of family setup. I was one time in a region of this country, which I will not mention, and I was giving a talk to RDCs and so many other people involved in Operation Wealth Creation and Hemioga and all that thing. And I told a story of how in the office of the Administrator General, we were once working on a file of a priest, a father, a Catholic priest. And he had 6 children. And when we were in the family meeting, the brothers of the deceased first took me aside and said, can we get letters of administration for his estate without advertising? Because it's going to be funny that the estate of the late Robert Ali Bogere, Reverend Father Robert Ali Bogere, and then the applicant is son and daughter. They were going to say, how will it appear in the newspapers that our brother had children? So these are things which even that priest, if he had been wise to this kind of situation, he could have made a will and appointed executors, and those executors may not even be his children, they may be his brothers, so that in death, his image is also somehow saved, so that we don't have to, when they advertise in the papers, they will see that Reverend Bogere, applicant for his estate, was his brother. Then it's the family name sort of is saved. So wills and estate planning helps you when you know your family situation and your relationships. It helps you to do a lot of good in that respect. Now, the best I can do here is to inform people that the best thing to do is to make a will. But what is a will? A will is a document which you make, which gives instructions about your estate and how you want that estate to be managed. Under the current law, there are things which you cannot distribute in your will, or there are restrictions. We've had men in the past who have been, he quarrels with his wife and he fears her, so he cannot chase her from the house. So many people stay in their houses when they are separated, within the same home. The husband stays in one wing, one bedroom, the other woman, the lady stays in the other bedroom. If she cooks food, he doesn't eat it. That's the scenario we have. So those men have been doing something. They would make a will, and then he says, let me deal with her as I'm dying. So he makes a will, says, when I die, my wife should leave the home and go to her parents. Or he doesn't do that purposely. He gives the home to a stepchild of his wife, the son of another woman, who knows will fight his wife and go. He evicts her. So we made a change in the current law, which says a person is not allowed to distribute his principal residential holding. You could call it matrimonial home, but that's not what the law calls it. You are not allowed to make a will distributing that property unless you have made provision in your will for for where those people are going to stay after your death. You give them alternative, reasonable accommodation at the same level that they were living with. So if you have a home in Kololo and it's on 1 acre, let us say it's valued at 30 billion Ugandan shillings, we don't expect you to make a will and give your spouse a 2-bedroom house in Nakapiripirit valued at 10 million. So if you are to give away your residential holding to someone, you are supposed to give in your will alternative accommodation to the people who have been staying in that property or who are entitled by law to stay in it, including your spouse and young children. I've seen wills which are very bitter wills, most Ugandan men especially. When they are making their wills, you see a person quarreling in 6 pages. Every page is quarreling with someone. One very wealthy man left a will giving all his assets, 90% of his assets, to one woman and her 4 children. One woman and her 4 children, and he had 16 children. And some of the children he did not give were babies, 2 years, 3 years, 5 years, because he had quarreled with their mothers. And the new one, the woman who had 4 children, whom he gave 90% of his estate, was the new catch. And she was the sister to one of his wives.
That is serious.
So she had come to his home to study, going from that home to go to school. And on one night he passed through the Kamori, and they ended up having 4 children with his sister-in-law. So that hatred between the 2 sisters made the situation volatile. The man disinherited all the children born of his real wife. He made a will that was so bitter and so bad, and we had to go to court, and court helped, and it was set aside. So there are things which you are no longer allowed to do in a will, that is including disinheriting children who are under you, who are under your care, minors. You may have even children who are adults, but who are totally dependent on you. Like you may have your children who are disabled, maybe mentally, and they are under your care. So if you disinherit them, whom are you giving them to take care of them? So those are some of the restrictions in when you are making your will. The other major issues to note when you are making your will is that you must be of sound mind. You must not be under the control of any person such that it takes away your authority. Because a will, as the word implies, it is your wishes, your will. This is like thy will be done, if I can format it that way. Now, if someone else is controlling you, then that's not that's their will. You are doing their wishes. If you are so drunk that you cannot differentiate between a cow and a dog,
Yeah.
then you do what? You you
Can't make a
you
will.
you cannot make a will.
Yeah.
The other thing is there is a tendency in this country, as I've said, to make wills when you're about to die.
Mm.
Many people in the office of the administration would come and I would ask them, did your father make a will? Then they say, no, he died very quickly. Then I then I look at the age of the man and he was 70. Then I tell them, what do you mean quickly? For them, they would mean that he did not get time to be sick and spend like a year sick
Okay.
so that he can make a will. So we all tend to think that death is so far away, and when it is coming, it is going to come in a fashion where we will have time, we get a pen, and so that's what they mean that yafama yangu.
Yeah.
He died very, very fast. Now, the other group of people are those ones who make wills on their deathbed. So you find a gentleman who has made 4 wills within the space of 1 year. And each will has a different heir because someone angered him after he named him heir. So you are on the bed in hospital or you are in a purposeful aging home. And if you call your son Bogere to come and visit you and your son is busy facilitating a Zoom talk and says, Dad, I will come after 2 hours. You say, bring my will and I change it. Then you remove him. This one, I called him and he did not hurry up to come here. So we have those wills where they are made in that I don't know what they call it. Elderly people, I'm not saying you people who are on this group. Elderly people and people who are sick are easy to anger, easy to irritate. So you find a will where someone is listing. I called him, he refused to come. I was sick for a week and he never came. But he doesn't know that maybe his son was facilitating a meeting in Chankwanzi of the political, and he cannot leave. He's booked for that whole period because he's the facilitator for that period. Or he was involved in some other important thing where he would say, I will come. And he maybe the son later came, but then you find that the father in that period has changed his will, has removed that son, has even disinherited him. So we should avoid making wills when for us in Islam we say don't make decisions when you are too much in love or too angry. Those two emotions will give the same result. You are too angry, you disinherit people. You are too much in love. Most men, especially the ones who marry young girls in their elderly age, most of those men leave most of the property to these young girls whom they marry towards the end of their lives. And you find this young girl maybe even has no child or has one child, and you have given her 80% of the estate, given her even the home which you built with the mother of your elderly children. So that always breeds conflict. You have given it because you are vulnerable. You think she's the best wife. She's the best woman who has ever been, who has existed. Now, when we sit down to make our wills, we should not make them off the cuff. Take time, think about what you want to do, think about your family dynamics, and make a will. So, essentially, the good will should have a date. The date is important. So many wills have been invalidated because of issues which have arisen because of the fact that they were dated at a particular time. I'll give an example. This is a live example, so I'll name it because it has gone through court. A gentleman made a will when he had mental illness. This gentleman, the owner of Nyondo Pub, was called Kasumba. And in that will, he did not give, he gave his smaller children, the three small girls. The eldest was aged 11. He just gave them the home in which they live. No school fees, no money for eating. And yet he had an estate worth probably 10 billion shillings. What gave up the will was that it was dated the day before he went for an operation to clear, I don't know what they call it, white matter off his brain. He had got a stroke and he was mentally disturbed, mentally, mentally ill. Another will, someone forged it and dated it the day after the death of the deceased. As if the deceased had died, then he resurrected and said, I had forgotten my wife. He resurrected, then he made the will, then he went back. So the medical certificate of cause of death said he died like today, 30th. The will, the people who were forging it, they forged it the day after his death. And that's the next topic. The person who forged it was his caretaker. She was actually a maid.
Wow.
When the man was dead, she called the young men from Bogorobi, and they made the will, giving her all the assets, and got the dead man's thumbprint and put ink on it, and put it on the will.
Okay.
So disputes came up. Disputes came up because she had promised to give them one of the deceased's 14 houses, and she had promised to give them 2, and she reneged on that promise. So that's when they came up and said, we are the ones who forged the will, whether they take us to prison or not. So that dating, someone just asked, they asked each other when they were in the mpozi lero nnaku z'omwezi mmeka, what's the date today? So they made the will in the morning when the death certificate said he died at 8 p.m. the previous night. So caretakers, caregivers, there's a case going on currently. You may have been aware of it. It's in the news. It's at Buganda Road Court, where a woman and her son, the ones who were caretaking the deceased, took the entire estate. They are being charged together with the lawyer who drafted the will. The children of the deceased were abroad. Their mother was here. The will came out giving her a huge estate worth tens of billions of shillings. So that vulnerability, us waiting to make wills when we are in that kind of state, it's a no. So I would encourage everyone, sit down when you still have your faculties and make a will. Another angle in that is people waiting to make wills and then they are vulnerable to their imams, to their fathers, to their reverend fathers, to their pastors. I've had to fight. I'm a Muslim. I've been disowned by some Muslim groups when I told them the will which they made the deceased to make, giving all her assets to the Muslim community in Najana Nkumbi, was forged. So it was illegal. I've had that fight with Catholics, with Protestants, with Barokole, with SDA, with the only maybe Baha'i I've not, but with the Muslims, all those groups, when a person is about to die, they go to give him last sacraments, if I can call it that. And then they tell that person, store your wealth in heaven where there are no thieves, where the moths don't destroy, where give your wealth to God. Then the poor woman would give all her property to the Muslim community at Najana Kumbi. And yet she has children. There's one who had a daughter of 14 years old, and they made her give all her property to an orphanage. It's illegal. It's illegal. It's a criminal offense for you to take advantage of a person in that kind of state, because you as a priest, as an imam, as a lawyer, as a doctor, you have a fiduciary responsibility towards that person. So another will, a doctor even got a share of the deceased's cars. The man was in hospital.
Jesus.
He was in
This is
hospital,
serious.
and his girlfriend, whom he had a child with 28 years before, learned that he was in hospital, and she came and in a will he gave her all her property, and even the doctor was given a property in the will. The doctor was one of the witnesses to the will. So in your vulnerability, don't surround yourself with people other than those who are always there. But even then, don't wait to make a will when you are in that kind of state, when you are vulnerable to, like that man who the doctor who took. There was a lawyer and a doctor and an ex-girlfriend of 30 years ago, and he never gave to any of his other 7 children anything. He gave them to that whom he called my sweet wife, a girlfriend of who was actually already married to another man. So Ugandans, as we know ourselves, we are not very good people. I will say it this, because you can imagine that that girlfriend was driven to that hospital by her current husband, and he drove her to go and coerce the old boyfriend to make a will giving them everything he owned. Now, make your will, date it, give us your names, give us your names, give us your spouses, your children. You shouldn't fear naming all your children in a will, even children who your wife doesn't know about it. After all, the will come out when you are dead. She will not beat you. She will not come and dig you up, and maybe what she will do, she will maybe kick your photos in the house. But you don't have to fear. Make a will, give us your children, give us a date, your marital status, your children, your spouse, your assets, and how you want to distribute them. If you have a child who is not serious in life, who you know that if anything you give him, he will sell off, you don't need to give him property, as in real property. You can give him income from it, and then you transfer that property to maybe a trust. You can make a trust, appoint trustees, or you transfer that property to another child whom you know that is very good at he's responsible, but you impose on that child a duty to give income to the other child who is not serious. I've seen people who have made wills and they quarrel about other children, that I gave him everything and he just drank all the property, so I've given him nothing. So give conditions in your will to whatever you are giving to any of your children. Now those conditions are allowed as long as they are not illegal. You can make a condition. For instance, I give Bogere my house at Najana Nkumbi, but he will pay school fees for his younger brother. That's a condition which is allowed. And Bogere will not take that property if he doesn't pay school fees, because he cannot pick and choose what he wants in my will. So the condition has to be, there is a famous condition which we learned about in school, where a person says, any child of mine who joins the army will never get anything from my estate. Now that's a condition which is against public policy. You are fighting government. If government wants soldiers and everyone was to say none of my children should become soldiers, where will government get soldiers from? So give a condition which is legal and allowed and it benefits someone else. After you make your will and date it and give your marital condition and your children and your dependents and your property and how you want to distribute it and any conditions you wish to impose on it, you name executors. These are the people who are going to implement your will. They must be trustworthy people. Don't just name people because they are of your faith. Name people because of their character. That's very important. We've seen most of the people who love our spouses are our friends anyway. Are people sometimes whom we know. We've seen wills in the office of the Administrator General. We used to see wills where a man names a brother, and then the brother has always been in love with the wife of the deceased. And that brother makes administration of that estate impossible. He connives with the spouse whom he has loved, and they disinherit all the other children. So be very careful as to the executors you name, the people who are going to implement your will, because that power which they have is a power which can be misused. Although current law restricts it in some way, but the fact that they can prolong the fight over your estate in courts of law, it will end up being wasted. The estate of the deceased will end up being wasted. So name executors, at least the bare minimum, of course, is one, but it's good to have 1, 3, not more than 5, because the more they are, they also get sometimes into disputes. Then you date your will and you sign it on each page. You put your signature on each page of your will, and then you have at least 2 witnesses. Those witnesses must be not beneficiaries in a will. Anyone whom you give a share in your will and they become a witness, that share is taken away from them by law. So don't put your wife in your will as a witness unless you really purposefully intend not for her to get anything. But 2 witnesses, those witnesses must sign and give their particulars on each page of the will. One common question is, do witnesses read the will? No, it's not good. It's not illegal if they read it, but if they read it, it's no longer now a secret. And one of those witnesses may be the girlfriend or boyfriend of your spouse. And they go and tell your spouse that, do you know that the heir is not your child, it is the heir of your rival. That may be your last day on earth, you as the maker of the will. In essence, that's the basic thing about a will making. This talk, I wanted to give more of it in what happens to an estate when a person has not made a will. I see I have like 5 minutes, 10 minutes maybe. Let me talk about an estate, which is going to be, which is the majority of our estates, where a deceased person has left no will. Most Ugandans, and I believe most of the members who are listening here, don't have wills. And if you would die in that state, people want me to say, God forbid. No, God will not forbid. If you die in that, if you die in that state of not making a will, this is what's going to happen to your estate, and this is the law. So if you have no will, the beneficiaries to your estate are your spouse, who gets 20% of your estate, your children, who get 75% of your estate. So that total between the spouse and the children is 95% of the estate. Then your heir, who gets 1%, which is 96. Then the dependent relatives. These are relatives of yours who have been totally depending on you for their livelihood. For instance, you have been taking care of your mother or your father. or your brother who has mental issues, and they have been under your care, those take 4%. So the category of beneficiaries is that spouse 20%. If there are more than one, they take 20. We don't add them because they are the only ones who they volunteered to go there. 20%. Children 75%. Heir 1%, and the dependent relatives 4%. Your spouse is the woman or man whom you have married. If they are not married to you, they are not your spouse. Marriage is customary, church, civil marriage, Muslim marriage, Hindu marriages, and other marriages done out of this country but recognized as valid here. For instance, a gay marriage done in the UK would not be recognized as a valid marriage here. So that spouse, a male spouse of a male deceased, cannot come here and say, I'm the widow, or I'm the widower, when the deceased was of the same sex as them. But in Uganda, if we go back to Uganda, if you're married in church, it is possible that your marriage is illegal if you already married to someone else customarily, and you entered in church marriage without first divorcing the other woman. Many men in Uganda do that. And you have seen them probably on TV, where there's a couple being wedded and a woman comes with kids on her back, crying, and says, I'm married to this man customarily, and she produces sometimes a marriage certificate, customary marriage registration certificate. But Uganda, as a spoiled country, I've watched on TV priests who get this woman who has come to object, and they shove her in these pickups of the police, and they drag her off, and they go on to conduct the marriage. That kind of marriage should never be conducted. If a person has come and objected, don't go ahead with that marriage. So the best to do is to consider that are you married or not. If there is a church marriage, that church marriage should have been the first and only. At the time it was celebrated, any of those parties must not be married to the deceased, to another person. So essentially, what we do, sorry for I'm at home. There is a child who keeps on, I don't know whether it's disturbing us, but let me get them quiet a bit.
Okay. We are not hearing anything.
Okay, sorry. Thank you. I was saying that if you are customarily married to another person, you are not allowed to marry another person in church. The only person you can marry in church, if the customary marriage is subsisting, is the same person you have customarily been married to. For instance, if you do a kwanjula, kuhinjira, then you go with that same person to church. That's a valid marriage. So if I die, that spouse is my spouse. But if I marry in church today, and tomorrow I want to be like Ujingo and marry another woman, Makula, and I run away from Teddy, my marriage to Makula is criminal. And if, for instance, I always like to give like example. If Ujingo were to die today without a will, Teddy, his married woman in church would get the share of a widow, even though they are in the middle of a divorce, because she can go to court and prove that our separation, which is there for everyone to see, was caused by Ujingo wanting to get another woman. So if your spouse dies when you are separated, the basic principle is that you don't get a share unless you can prove to court that the separation was caused by them, or they are the ones who left. The deceased caused the separation, or is the one who left, or we were separated because of me living in another country because of work purposes. So spouse is a very important issue, and it must be settled. Many Ugandans who are in cohabitation are not spouses. Some of them even end at kuchala. This visit, the ceremonial visit, which you do before the wedding, the kwanjula. If you do just a kuchala, you're not a spouse. Some people even impregnate other people's children, and they are made to pay a fine. If you pay a fine because you impregnated someone's daughter, that fine is not dowry. You just pay the fine, you are not married to that person. So that is the brief on it about marriage. It is a very wide topic, but because of time, we can't finish it all. That spouse will get a share of 20% if she's married to you, except if she was separated and she does not follow into the other exceptions. For instance, she may have been separated and she's the one who caused the separation. She ran off with another man, or he ran off with another man. The other alternative where a spouse, yes, I've seen that is kwanjula a marriage. Kwanjula is a marriage. It's a customary marriage. Kuhinjira is a customary marriage. That marriage is polygamous potentially. So it means that that person who was customarily married can marry as many women as possible. It is not it's for women, it's one man. But for men, in a customary relationship, he can get as many as possible. But if he tries to again convert it into a church marriage, he cannot do it if he's already married to many women. He can do it to convert it if he's married to one. The other alternative, if he wants to convert, he must first divorce all the others and convert with only one person. The other instance where a spouse will not get a share in your estate if you die without a will is if that spouse kills you. There's a current case which is going on in the papers. You know about it. I will not talk about it aloud. But if that person is convicted, it means she will not get a share in the estate of her husband. The estate of the late Nsenga, I think it was called Nsenga. No,
Yes, of Golori.
Yes, the one where the wife knocked him at the gate.
Yes, Nsenga.
Yes, Nsenga, the wife got nothing from that estate because she was convicted of killing him. So she remains a spouse, but without getting a share, because you are not, public policy forbids you from benefiting from your own criminal activity. So that's all for spouse. Now, children. As for children, they are either biological or adopted. Both get the same share. An adopted child gets the same share as a biological child. The other issue about children these days, there's been a flurry of DNA testing. People, when a person has died, and this will happen to your estate if you don't die with a will. One of the children will come and say, our dad told us Bogere is not his son. But he just left him there because he did not want to be embarrassed in public, or he didn't want to embarrass his mother. So children these days are coming up and causing DNA testing to be done, purporting that the deceased denied his paternity, or that they want to be sure. Now, under Ugandan law, there is no law which mandates a person to do DNA on others. It's a law maybe which is going to come up, but currently DNA can only be done by either if they agree or if there's a court order to that effect, which says, let us do DNA. What I will tell you from practice is that most DNA testing done in this country, a lot of it is fraudulent. We all know where our country is with the professionalism, with the corruption, with basically we are rotten to the core. Sorry for saying these things, but we
We
have
appreciate.
we have situations where someone will forge DNA testing
Mm,
and forge results because of who has paid him. And they will disinherit you from your father's estate when you are
mm,
actually when you are actually a real beneficiary in that
child.
estate.
Mm,
So people are being disinherited through forged DNA. I've handled the estate. We were handling an estate of the late Paul Cafero, for instance, this musician, and some of the children went and stole property. And after stealing it and selling it, they then came and said, "Some of you are not children; the others who had not stolen." Then they said, "We do DNA," and DNA miraculously came out when the thieves were the only beneficiaries. So
oh my God.
this country where we have reached. So the
Yeah.
best to do if we are to force DNA, and we rarely do it as the state entities don't like, because if you start saying DNA should be the standard to be done on every estate, then this country is going to go to catch fire. So what we do, if people really insist on it, we say go and get a court order. If the court says we do it, the best DNA to be done is by digging you up. And they break off bones from you, and then we go and do DNA. And we just hope that the laboratory doing it are ethical people. So if they dig you up and do DNA, because if you say let us do DNA with the brother of the deceased, you may find that that brother is not your real brother also.
Mm,
There's a famous case where DNA was done on a brother and it turned out on a sister. And the two children were fighting to become the next lord in England. There was a fight over a lordship, which was worth like 20,000 acres, more than more than 40 square miles of land, almost. And DNA came and showed that the two fighting boys were not related to their auntie. So they brought another uncle and also did DNA on him, and they realized that the uncle and the auntie were related, but not to these boys.
okay. Mm. Hello. Council Bogere, are you still there? We've lost you. Hello. Hello.
We hear you, but it seems we've lost
I think
Council.
we've lost him. Yeah.
Maybe let's give him, let me try to call him and give it a few
Okay.
minutes.
Because you might be dealing with a child again. We're getting a lot of homework here. Give ourselves a present for Christmas. Making a will. Yes, we do get a YouTube recording. It may not be immediately after, but it will be available. And I think someone wanted to know about a template. Many templates online under Ministry of Justice. But let's wait for him to give us the answer. The YouTube channel, let me copy it and give it back to those who have come in.
Okay, I think he has rejoined.
Yes, I'm very sorry. For some reason, the Wi-Fi, the router went off. I don't know why.
Welcome back.
Okay, sorry. Sorry. Let me summarize it and say that we tend to think that you will do DNA on your brother, and it will solve the family issue. But it may be that that brother is not yours. It's not your brother, and then it will disinherit your children. So the best, we go back to the other issue that if you have raised children and you have raised them, make a will, provide for them, and some of these other issues which we see will go away. Even sometimes if you know that this child is really not mine, and you did it to protect your wife, or maybe she also caught you infidelity, sort out those issues by making a will. I've seen a will where the two couples, the son and the lady, the man and the woman, each made a will, each admitting that they had a child out of wedlock. I don't know they really loved each other and then they made a will giving each other property in case they each survived, each did not survive the other. So the wife in her will gives all her property to her husband. The husband in his will gives all his property to the children, to the other spouse. And then they listed all their children and said, if my husband dies before my children will take. So that's to do with children. The other thing is, if if a child also kills the parent, that child will also not get a share in under that estate, the same as any other person. One issue which always disturbs people is children who die before their deceased parent. If I have 5 children and one of them dies before me, do they take a share? Most people customarily think that they should not take a share, that they should say, how many children did the deceased leave? No. Under the law, we say, how many children did the deceased have? How many children did the deceased have? So if I had 5 children and one of them died before me, the law will give him a share, him or her a share, if that child of mine left children who survive me. Meaning, they are grandchildren of mine at my death. On the day that I die, they are grandchildren of mine born of my predeceased son or daughter. So when my estate is being distributed, if I left 3 children, but then I had another one who died before me and leaving his children, my estate will be given to 4 children. So these grandchildren are not the ones who are sharing in my estate. That's where the confusion comes in. My dead son who died before me is the one sharing. He shares with the 4 living children, or with the 3. And then his share is taken by his children via his own estate now. So a predeceased child who left children of their own gets a share. Same thing which I forgot to mention. If by the time my estate is being distributed, my wife has remarried, my wife will be given a share. My widow. Let us say I die today, and because of legal issues, as people are in court or some other issues, the administrators don't distribute my estate for another 5 years. And meanwhile, my wife, who I married young, has remarried. That doesn't take away the fact that she's my widow. Because her share in my estate falls in place on the day that I die. And on that day that I died, she was not married to anyone else. She was married to me, and she was my widow. So her share and the shares of everyone, all the children's share, all the shares of the heir, they fall in place on that day that I die. The minute I die, people's shares are allocated by law. So 20% is allocated to my widow. If she remarries 5 years later, she's entitled to come and get that share. When we were in the Administrator General's office, we used to have women whom she would come like after every 3 years as a new widow. So we started calling them professional widows. Like, how do you succeed in all your husbands dying like this? And we had another issue. We would notify that we would note that most of the clients of the Administrator General are widows. We used to say that women don't die; they just fade away. So you would have, if we saw a widow, we almost want to give him a hug and say, how did you manage to do it? That she also died before you? Give us the tricks. This is just a joke. But the truth is that women, it's very rare for women to be outlived by their men. Usually because, one, we marry them when they are younger than us. And then another thing is we take more risks. So that is that for children. For the widow, for the dependent relatives, they must be, one, a relative of yours. Two, they must be totally dependent on you. A maid is not a relative unless she's a relative, like some people who get their relatives as maids. A maid is a worker. So if you are a caretaker, a caregiver to one of you people on this meeting, and one of us on this meeting passes away, you, the caregiver, may have been totally dependent also on this person you are taking care of. For instance, they were meeting all your daily needs. But if you are not a relative, you don't share. You don't get you are dependent but not a relative. So you don't take in the 4% which is provided for dependent relatives. Secondly, you may be a relative and a dependent, but when your dependence was just because you were working there. So people who can fall into that category of dependents include your parents, your wife's relatives, because your wife's relatives are your in-laws. So your wife's father becomes your father-in-law. So if you are taking care of your father-in-law, he will take a share. Of course, the father of your girlfriend is not your father-in-law, because his daughter is not your wife. Both your wife, your girlfriend, and her father have no share in your estate, even if they were totally dependent on you. They were not relatives, either in law or by blood. The customary heir takes 1%. That one is appointed by the clan. So we have a situation, as I conclude, where if the deceased leaves no customary heir, the share of the heir goes to the children. If the deceased leaves no spouse, the share of the spouse also goes to the children. So the children can get 95%. If they are not dependents, also that 4%. So the children can get 99% of the estate. In the same way, if I have married a woman, let us say today, and I die next week, we have no children, and I have no dependents, but then they appoint a customary heir for me, my wife will take 99% of my estate, and the customary heir will take 1%. If on the other hand, I marry my wife today, and we don't have children, and I die, but I'm taking care of my mother will take 49% of the estate. My wife will take 50% of the estate. And then the heir will take 1%. So the heir's share doesn't increase at all. In actual sense, if I die without a spouse, without children, but then I have an heir, the estate of that deceased person, like me, in that circumstance, is distributed equally amongst my nearest relatives. If I have brothers and sisters, they take equally my estate, and the heir will not take anything unless he's one of those nearest to me. So thank you very much. Because of time, I will limit it myself to those issues.
Thank you so much, Councillor Bogere. I think this has been a very, very informative session, and I can see we have a lot of questions and probably discussions come up. So I'll immediately ask Dr. Philippa to take on the Q&A, and we use our 30 minutes profitably.
Right. Thank you very much. And thank you, Council, for making a very difficult topic very interesting and humorous for us this morning. I think one of the first questions, which we tried to answer while you had dropped off, was where one can access a template for a will. It had been suggested that the Ministry of Justice website has a template which could be accessed by all. You could just confirm if that is okay. And
Thank you. But I wouldn't encourage people to use templates.
Okay.
Because they make you robotic. They just fill in here, fill in here. There's no space for you to express yourself. It is a guide of the important things which are important in a will, but it is not a good thing to follow totally.
Okay, what would you advise someone who has used a template to do? What would be the idea?
When you look at that template, it is it's supposed to be a guide for you, but it may not have enough space for you to, for instance, make directions. You would have to add another piece of you have to add other paper. It's a good guide, but it's limiting. Let me put it that way.
Okay. I'll
Yes.
just have two more follow-up questions which have appeared in the chat related to a will. One is that is a will which is made without a lawyer, but with a witness who has signed all pages, like you said. Is it a valid will? And isn't it void for a dead person to appear in a will? If it happened, does it nullify the will?
Very much. A will which is made by a non-lawyer has no problem. But most Ugandans have no access to lawyers. So the basic, and why we put out those forms, is to show people what are the essentials. In law, we say there is no format for a will. They are just essential things. So if you put the essentials on a document and you intend it to be your will and it is signed by, I'll give us basically a difference is, did you realize that a will has the same essentials as an endagano, has an agreement to give land to someone? Isn't it? An agreement where I'm giving you a piece of land has a date, has my names, has your names, has what I'm giving you. It has my signature, your signature, and 2 witnesses. But a will is a document you make intending for it to come into effect after you die. So it's different from an endagano. From the agreement is immediate, takes in effect in your lifetime, isn't it? So the best thing is, if a document meets all the requirements of a will, it doesn't need to be signed by or even drafted by a lawyer. But the reason we encourage people to go to lawyers is to avoid those traps which I've spoken about, where a person makes a will and he gives to the church, he gives to the mosque, because he has been cornered somewhere. He has been cornered by people somewhere. Although one of the examples I gave you, actually 2 of them, they involve lawyers. So you must have people you trust, whether they are lawyers or they are not lawyers. Those people must be people you absolutely trust. Secondly, what if a person makes a will, and I think that's the question, and he names a dead child in it? If I say to my son Bogere, I give 1 acre, when by the time I make that will, he is dead, is that the question? If it is, it raises issues. It raises issues. Under a will, you can't give people who are dead on the day that you are making it. If it's a mistake, if it's a mistake, and you name one of your children as living, one, it can lead to a thinking that you did not have control of your capacities, isn't it? Like you could not recollect that you could not recollect whether this child was alive or dead. There are wills which we have seen like that, where a deceased person names his dead children, even gives their years in a will when they are dead. So either the will was not made by him. That will I've told you of the lady who went to the former boyfriend. She listed one of the children as dead when the child was alive. Her stepchildren. So it could show you that this will was not made by the father of this child. Now, there is giving property to a class, and you say, my property is for my children. The law says any person who is not alive at that time amongst children will not take a share. So any dead child will not take a share. The law will consider the children living as at that date when you made the will. But if you name people and say, I give to Bogere, Jane, and James, and they are all alive, even if they die later, they will still take that property. I don't know whether I've been... Any person you give who is alive at the time of making the will take the property. But if you give to a class, I give to my wives the house in Namasuba. Any wife who died before you does not fit in that class at the time you made the what? The will. Yes.
Right. Okay. Right. There's a question about children. If the deceased doesn't leave a will, who are these beneficiary children? Are they children of the married spouse? What happens to a cohabiting couple? Those are
Yes.
2 questions.
If you leave no children, the law doesn't call your nephews children. In Uganda and the other customs, they call them children. But legally, if you leave no children, as I've said before, your spouse's share increases. 50% if you have dependents. People who are wholly depending on you. Your wife's share will be 50, the dependents will take 49. If you don't have dependents, let us say me. Right now, if I was just out of law school, I've started working for a year, my father is not depending on me, my mother is not depending on me, I'm just starting to work, isn't it? It means my brothers and nephews and nieces may also not be depending on. But now, if I marry, my wife will take 99% if I die, because I have no children, I have no dependents. My wife will take 99% of that estate, and the heir will take 1. My wife's children, it's an issue which comes up also. My wife's children are not my children unless I adopt them. But
Okay.
my wife's children are my stepchildren. They have their father or fathers. They are
Can be dependent.
Yeah, that's where I was going. If they were living with you and totally depending on you, they share as dependent relatives because the children of your wife are related to you by marriage. You have married their mother. But as I said before, the children of your girlfriend, the children of the woman you are cohabiting with, the children she had with other men are not related to you at all. Because even their mother is not related to you. Their mother is your girlfriend.
Girlfriend.
She's not your wife. She's the woman you are cohabiting with is a girlfriend. The man is a boyfriend. The man's children are not your stepchildren because you don't have a relationship with their mother. You know, these laws, sorry to meander, these laws are related. The law on marriage brings you into succession. It also brings you into, for instance, in the penal law, in penal code, under the penal code, if I accidentally meet my wife and with another man in a bed, let us say I've come to my home earlier than expected, and I meet my wife in a bed with another man. Out of anger, if I get her or him and beat them and they die, I have killed them, but I've not murdered them. Yes, that's the law. I have committed manslaughter. I've committed manslaughter. Yes, it's a killing, but not murder. You see, murder, you form intention. You plan. But now, these ones, I have just landed on them. And out of anger, the law calls it provocation. I was provoked. But if I meet a woman I'm cohabiting with, even if I've cohabited with her for 10 years and we have 5 children, and I meet her in the same circumstances, in a bed with another man in my house, on my bed sheets, on my pillow, the law doesn't allow me to get angry over her.
Okay.
If I kill that man or her, I have committed murder. Because I have no, in Luganda we say, tetumina ko kakwate. I have no connection with this woman by law. I am not allowed to be provoked because I am also like that other man. He's also her boyfriend, just like I am. So you can see that we don't want to give a cohabitee a share in an estate because legally she has no claim to the deceased. So her children cannot be dependent relatives. Yes.
Okay. Right. There's a question about where does GRSD come in when it comes to marriage certificates. I think about whether the marriage is valid or not.
Yes. Marriage certificates are not actually what makes a marriage valid. The marriage is valid because of the law. For instance, we may get married customarily. There's a requirement by law that we register a customary marriage. But non-registration does not make a customary marriage invalid. Now, for a civil marriage, a church marriage, there is a requirement that it must be registered. It must be registered. That's a requirement in law. But even for that one, you may have lost your what? Your copy of the certificate. But if you can go back to the book, to the register, the real register is actually the book. If you go back, if you can prove that there's a book where we were registered as married, where we signed, you know that book for you people who get married in church. You know there is a church register which you sign, isn't it?
Yes.
So that is the register. The certificate is proof, but the real registration is there. So even if you don't have a marriage certificate, but if you can prove that you actually did the marriage and it was registered, maybe you lost your certificate, that you are still a married person. For Muslims, there are also marriage certificates issued, but the essence of it is not. That's not the essence is that you have. For instance, I may have a marriage certificate, but when I've married my sister, I'm giving you a scenario.
Yes.
Is a it's that marriage is a nullity. You're not allowed to marry people within certain degrees. So even if the marriage certificate itself alone would not be like I've told you, you may have a marriage certificate, but when your husband was already customarily married, remember the things which happened to this musician who went out of the country, Judith Wabidi or something.
Right. Yes. Yes.
So you
Yes.
you marry a man in church when he's already customarily married. So you and your church marriage and your marriage certificate, it's all of it is evidence of criminal activity. Because the man was already customarily. The best you would have done is to marry him also customarily. There is a trust. Someone is asking to comment about having a trust versus a will. A trust is basically a vehicle which can hold property set up by you, the settler, the person who is going to relate it with the property. For instance, I go to URSB, I reserve a name. After reserving a name, I appoint trustees who are going to manage my what? My affairs.
Trust.
Yes, that trust. That trust, the beauty with the trust is that it avoids administration of the what? It avoids these issues we have had about. It's not foolproof. People can always quarrel. Ugandans will always come in to do what? So with a trust, you draft what we call a trust deed. A trust deed is a document which outlines the purpose of that trust. For instance, you can be that I'm setting up a trust fund for the education of my children. That would be the purpose. Or I'm setting up a trust to hold property for the future benefit of my children. So the purpose, then you name the beneficiaries and you give the powers of the powers and responsibilities of the trustees, the people who are going to manage that trust. It may even be you as the first trustee until you go. So after that, you must submit those documents to the Ministry of Lands to do what we call incorporation. The Ministry of Lands is the one which issues you with a certificate to do what? Which says your trust has now basically it's now a legal entity which can own property. So a scenario I can give is if I have property in my names, I can then transfer that title into the names of the trust, Bogere Robert Ali Trust, Children's Trust Limited. Then those trustees will be the ones to manage that. So they don't have to go through getting letters of administration, getting letters of getting probate, or sitting family meetings to nominate them. It is you who appoints them. They are like executors, but they are executors of a trust, not of a will. They are in charge of an entity which already owns the property. So it's a better mode of dealing with your estate than a will, because a will can be challenged easier. There are so many other things. But a trust, it's something you set. Now, there's also a scenario that you can set up a trust within your will itself. So you can name it a trust. You can say the following properties are going to be transferred to a trust. So you can create a testamentary trust. Then you can also create a living trust, which you can set up when you are still. The best example I can give you of trusts are like things which are managed under Uganda Retirement Beneficiaries Benefits Residual Authority, which many companies, many entities have retirement benefits for their employees. So their trustees registered under the Uganda Retirement, that thing is a mouthful, Uganda Retirement Benefits Regulatory Authority, something like that. So it is a document which you make. It's a legal document. It's better when you are making it. Now, I will not encourage you to make a trust when you don't have legal representation. It's totally different from a will. It's a bit complicated.
Okay.
What about in the event that the customary marriage was not registered? I answered that. The law says registration or non-registration does not make a customary marriage invalid, although it makes it difficult to prove. One time I asked it's a common thing, I asked a woman that, were you married to the deceased? She then started asking me now questions which I should have been the one asking her. She asked, what is marriage? I said, what did you go through? He says, how do they marry in Uganda? I said, how did you marry the deceased? She said, maybe customarily. I said, okay, what did you do? Then she told me, what do they do? I told her, I told there must be family consent from your father's side, there must be dowry and all that stuff. So she brought me a photo of herself and
We're having issues. Cancel.
which was done, and the father of when the man died, the father of the man refused to recognize his daughter-in-law because she had refused to sleep with him. That practice is there in some cultures. It is dying out, but it was there that your father-in-law is the one who should first sleep with you before your son sleeps with you. Your husband sleeps with you. Sorry. So I handled an estate where the father-in-law of the widow was adamant that my son never married this girl. And the brothers of the deceased were adamant that our brother married this girl. We went to the marriage. We did the kuhinjira. But our father, the reason he is refusing, because this girl, being a Molokole, refused to sleep with him. So you can imagine that kind of situation where your in-laws fight you and they refuse to recognize your marriage because one of them loved you and you have refused to have sex with them. So proving a customary marriage is difficult if you don't have that type of thing.
Right. There's a question
asked,
I've put on the site.
mm,
An interesting question. I know that many times men tend to have more property than women. So the question is about what about women tend to have what they call a centers-age child. What about how do you handle that? Like if the female dies before the male partner,
we always say that
and the property is not known to the man.
center age case is not legal tender. Anyway, that's a joke. It's a joke, but people always say that center age case. Now, most of the difficult estates are women's estates. As you have said, some women hide property from their husbands. Some of them register that property in the names of their siblings. or their mother or their parent. It's a very dangerous thing to do because your sibling will take your property. Your sibling may die before you, and then his children think that it is his property because the endagano or the title is in his names. Law treats the estate of a man the same as that of a woman. The woman should be to her parents, her lineage in the side of her, because these children are not from her clan, isn't it? So they always want to chase away the children of the woman and say that this is you have your father. Go, you are not. They even want to give that property to the woman's heiress, who is usually her sister or her niece from her brother. The law says the property of a woman also is distributed in the same percentages. The widower gets 20%. Same. Children 75, heir 1, dependents 4. So what it means is that if we can prove that any particular hidden property is for the deceased, we take it for her children and her spouses, and the what? The rest as it is. Yes.
Right.
There is a person who has asked a question here that what happens if in my will I choose not to include people I don't want. It is valid as long as the best to do is to give reasons. For instance, I've handled several wills. One of them, a deceased person says, my son Bogere beat me 3 times. He accused me of loving his wife in public on 2 occasions. I gave him educated him. Instead, he wasted his years. That's how we put it in Uganda. 3 pots as in Ensua, the ones where we put drinking water traditional. And he put there a star. That deceased man put there, the testator, the make of, they will put there a star. And he started giving other children 10 acres, 50 acres, 100 acres. Yeah, he was a wealthy man. And he said, at the end, he said, where the 3 pots I gave my son Bogere are those which he broke on the day he beat me. Meaning even the pots were not there. So he gave genuine reasons. And when that man went to court, because I've realized, and many of you will realize that in matters of estates of deceased persons, the longest living children, I'm not saying it about you people, so forgive me if you're the longest living in your family. People who live longest are usually very bad. You may have an estate dispute and you have an uncle, and this uncle is not dying. All the rest of the good uncles have died. The good aunties have died. So in that estate which I'm talking about, all the good children whom the father gave died, but this one who was given 3 pots was the last remaining, and he wanted to be the administrator of that estate. And we told him, but you have no share. You have 3 broken pots. And he took us to court, and the judge looked at him. The judge is a judge whom I will not. Sometimes he would address people in Uganda in his court. He said, you beat your father. You accused your father of loving your wife. Do you know how that is in Uganda? How that is a very, very terrible thing. And you want to administer his estate. He said, I wish I could beat you up, but I cannot. I'm a judge. The other will, which I found, another will, a very common practice, a mother gave her daughter a Bible and 2 verses. Okutya Mukama magezi mugatandikira, and is it respect your parents and you live longer, something like that. You know those verses in the Bible?
Yes.
This was a cantankerous daughter. She just did everything which could be done to a parent, and the mother gave out her property to other children, and for this one she gave her only a Bible and those 2 Bible verses. So if you give reasons which are sound, you can disinherit anyone you want, but not minors. That's a caveat. You cannot run away from your responsibilities for minor children and dependents who are totally depending on you, who are still in school, like children 25 and below, who are still in school and unmarried. Those are your responsibility as a person. So you can't make a will running away from those responsibilities.
Right.
Then
That means that
if there is
a child who's working, that means a grown child above 18 who's working and gainfully employed, you can
there's no
disinherit if you
yes
so please.
yes there's no
Reason.
law which commands you to give them.
Right.
Yes. So
Okay.
there's also a question here that if there is no customary marriage or any valid marriage, okay, that's that one. I think I answered it.
I think most of them you have addressed about the marriage. Whether you can my son or daughter be one of the trustees?
Can.
Think-
I see someone
Okay.
says, I need clarity. If a man has 5 wives and one died, how is this handled in a will? Is it a must that a spouse should benefit from the will? Now, if if I have 5 wives and one died before me, there are 2 scenarios. One, did she die before I made the will? If she died before I made the will, then she was not my wife on the day that I made the will. So I'm saying,
that would be died.
yes, if I have, let's just say I married 5 women, I have 5 wives today. Then next year I make a will, but my wife dies the day before I make the will. So it means on the day I made the will, I had 4 wives. The 5th died before I made it. So on the day I made the will, she was not my
Fine.
wife.
Oh dear, we lost you there.
So I think in the will. I'm saying if I have 5 wives, but one dies before I make the will, it means that on the day that I made my will, I had 4 wives because one was dead. So she was not my wife. I had no obligation. It's a different thing if on the day I make my will, my wife is existing and I give her something and I say to my wife Margaret, I have given a house at Makerere. Now, remember my will comes into force on the day that I die. My will comes into force on the day that I die. If on the day that I die, my wife has died, but I gave it to her by name. I gave it to her. I gave it to her by
Name.
that property will go to her estate. That is number 2. Now, number 3. Number 3 is this. If I give property to a class, I give to my wives the property in Najana Nkumbi. If I give to my wives the property in Najana Nkumbi, only those who survive me will take. So there are 3 different scenarios. If you give a person and you name them, and you give them by a name, that property, they will take it even if they die before you. But if you give a property as to a person as belonging to a certain class, all my wives, I give my building at Mutasa Kafero Plaza. if dies before you, it will force the day you die, although you may have written it 10 years ago. So on the day I die, who are my wives? Remember, this is a gift to a class, not
Pastor.
to specific named people. In your estate, as and even though they were in a class relationship, are children. How do I mean? I give my property to my sons. Any child who dies before you but leaves children, that one
Yes.
the law allows him to take, because these children are your blood. These children are an extension of your son who died or your daughter who died. So all other classes of people would not take a share except the class of a child. So if you say my wife, if she dies before you, she's not your wife, isn't it?
Yes.
So she doesn't belong to the class wives on the day of death because she was not there. But if the law specifically allowed gifts to the class children to survive if that child left children, because they are an extension of you.
Yeah.
Thank you.
Right. One last question that came in. Please elaborate more on loans, security, and property inheritance.
In loans, security and property
Yes.
inheritance. Security, I don't know what they mean, but loans, if a deceased person died having loans, those loans by law are a first charge on the property before we share anything in your estate. We must pay off debts owed to government and owed to people. For instance, secured debts, government taxes, they must be paid before your children before the estate is counted as an estate. One thing I forgot to say, if in an estate where there's no will and there are minor children, that's children below, okay, there are children below 25 who are not married, who are going to school, and they were dependent on the late. Before we distribute your estate, we must take off 20%, a maximum of 20%, to cater for those who are in school. Let us say I have one child. 20% may be big if there's only one child. In an estate like, let me give the famous estate of Sudhir. If Sudhir was to go and he left one child, 20% would really be humongous. So you take off what is necessary, but the maximum is 20%. So that 20% maximum is not seen as a distribution. It is only to make sure that these children go to school and finish school and go through life until they are independent. So that 20% is what we first take off before we go into what remains is what we share in the other percentages I told you. What remains is the 100% now. I don't know whether you get it. Let us say I have 100 cows. And I have 10 children who are going to school. So 20% will be 20 cows taken off. Now, the 80 cows which remain is the entire estate available for sharing. So we say how many cows did the deceased leave for sharing? 80. So that is the 100%. So we say the widow will take 70%, 20% of 80 cows. The children, 75% of you. I think you have got it. The children, 75% of 80 cows. The heir, 1% of 80 cows. Because the 80 is what is for sharing. The
Available.
other 20, yes. So the other children who are minors will also share equally under 75.
As children.
Yes, because remember the other 20 is not a share. It is like insurance for their education. So loans, we also treat him like that. That we treat them like that. If a deceased left 100 cows, and then 20 cows are the money for loans goes to 20 cows, we first take it off. We first remove the loans and pay them before, because remember, you as children, there's nothing you are inputting in this estate. You are just sharing. You are like birds which go without digging and go and start eating rice. So even you, the creditor gave your father something. So they must be under the law. That's why under the law, if a creditor comes and the children, in fearing the debts of their father, refuse to get letters, a creditor can get letters of administration over your estate.
Mm.
And
So
they
that
pay
means
themselves off.
So that means if you leave a will and you've properly distributed your estate, the creditor can come and claim.
Yes. Even if you have distributed everything and it is completed, and then it comes about that you had loans. For instance, you were defeated in court in a matter, and people have costs against you, and you fearing your costs, you decide to die. We will not allow you to escape your obligation. We will come to your estate and cost it and say we want the money owed to this creditor, and we reduce your children's shares accordingly.
Right.
Yes.
Understood.
Is a customary marriage recognized after a church or civil marriage? I said before, Bujingo was married to Teddy. Then Bujingo went and went for introduction of Makula. That what he did is a criminal offense, which is entitles him to 4 years in prison.
Wow.
So it can't be a marriage. That's why when he was found out, he said he became like Peter with Jesus and said, Simumanyo mukazi simumanyi. Said, I don't know this woman, I don't do this, we just did a kuchala. Because he knows the moment he says we did a kwanjula, it is a criminal offense of bigamy. But the other side is also true. If Bujingo had married Makula customarily, and then while Makula is still living with him, Bujingo pretends that I've gone to Nairobi for a business trip, when in fact he's going for marriage. And he goes to the civil registry and marries church and marries Teddy. The marriage of Teddy would also be a criminal offense. So a church marriage is not superior to a customary marriage by law. They are equal. The one which was first is the legal one. If you marry woman X in church, you are not allowed to marry woman Y customarily. If you marry woman Y in custom, you are not allowed to marry woman X in church. You can't mix, because there are two different laws which govern those marriages. The church marriage says 1-on-1, isn't it? The customary marriage, you can marry even more than 1 billion wives. So you can't have your legs in those two laws at the same time, except if the person is the same. You can marry a woman customarily and you go to solemnize the marriage. The other exception is there are marriages which were done like that in the 70s, 60s, 50s. People who were already found to be in that mess. They had married in church, then they married customarily. Before the marriage, the Customary Marriages Registration Act came into force. Those people were those laws were saved. They were allowed, those people were allowed to go ahead with their marriages because they were already found when they were in existence. But you can't do it now. Thank you.
Right.
Also,
Thank you.
just to add on that, so if I give wife number 4 property in the will, it's okay. It's okay. It can't be overturned. That
let us say you are married to woman number 1 in church, and you mistakenly do other things with other women. The law
yes.
allows you to give the wife in church property in a will, and you also allows you to give your other women property in a will. That's where I started from and say that as men, we know the kinds of families we have, the complicated families we have. You may have, yes, you may have your wife, the wedded wife, when she's very good with looking after children, but business-wise, she's not good. Then you get the woman who is my wife, the lawyer Mutendek, and you've married her, and she gives you that satisfaction as a husband that I have really married a beautiful woman, peace of mind, but she's also bad in business. Then you marry another woman, now they call her the ordinary wife, and she's very good in business, so she develops the family, but that woman is not married to you legally because you had the church marriage. That woman's business intuition is very high. She makes all the money for the family. Now, if you die without a will, that woman will get nothing. The rest of the women are benefiting because of this woman whom you've never married. So the best for you to do, I've seen a will like that. For instance, I saw the will of the late Mabirizi, this man who owns Mabirizi Plaza.
Plaza.
Eh?
Yes.
That owner of Mabirizi, he left a will and said exactly those things. I know I have my wife, X, but I know I have another woman who is not my wife, but she is Y. To my wife, I give this. To my other woman, I give this. So remember that property is yours. So you are allowed to give it even to a friend. So it is allowed as long as you don't become too unfair on the spouse whom you married, so that you give them reason to start challenging those things. You may land, unfortunately, our judicial officers are also human beings. You may land on a judicial officer who feels like marriage should be in a church, should be sanctimonious, and she looks at these other women as, in quotes, garbage. So that judicial officer may end up in a situation where she or her or he disinherits these other women whom you have given, because of, we all have our biases. We are not supposed to have them as public officers, but we do sometimes. So make a will which is fair. Yes.
Right. I don't see any hands up. I think that would be the end of our Q&A session. Someone is asking for your contacts. If it's okay with you, you can post in the chat. They want to get in touch with you for further engagement.
That is the only contact I have. The best thing is to contact me by WhatsApp. Sometimes when we are in courts, I may not pick. So you can simply say, oh, this is so and so, I was in this talk. Even an SMS. That's if you call and I don't pick.
Right.
I will call back.
Thank you very much, Council.
Thank you very
It
much.
was a very nice talk, very eye-opening. It is really good to have this knowledge. I'll hand back to the moderator.
Yes, thank you so much, Dr. Philippa, for running the Q&A session. I'm sure many questions have been covered and we are all wiser, a lot wiser than what we were at the beginning. Council Bogere, we are very, very grateful. You've enlightened a lot of dark areas which were in our minds, and they actually keep stressing us. We are wiser, and I'm sure many of us will embark on getting our wills down on paper to save a lot of this up and down lawsuits when we have rested. Purposeful Aging will continue with us next in 2025, and we are all welcome to give suggestions of topics or areas where you would like to have talks, or even having Council Bogere right back with us. And sadly, this will be the last session of the year, because I'm sure all of you are pretty engaged at the end of the December. So we'll see you in January next year, but do not hesitate to look at our past sessions on YouTube, share them widely, because I think they've covered a lot that can help us as we age purposefully. Our caregivers, thank you so much. You both worked with us. Normally, we don't see your names on the forum as we engage, but we know you are there, you are listening, and we've even been given tips of how to handle each other in ways of making our plans for succession. With these few words, I want to thank you so much and wish you good holidays, happy holidays. Some of you call it Christmas holidays, and a happy new year. Thank you so much once again, Council Bogere. Don't be surprised when we knock again at your door. You've been very, very, very clear, very, very ordinary. We don't feel like we've been turned into lawyers at all, but we have been engaged. We've been engaged, very engaged. Thank you
very
so
much for
much.
having me.
You're most welcome.
Good weekend.
Bye-bye. Bye-bye to all of you.